All right, so for the purpose of today, I'm going to talk to you about a case example. And the case is an employee of yours whose name is Joy. And Joy is not very joyful. She's very unhappy, and I thought I'd put this picture up of Joy because this is how it really captures how Joy feels inside. She goes into work every day. She's very unhappy. She sits at her desk and she's miserable. So Joy has been up to no good. Joy has been sniffing around for a new job, and lo and behold, a competitor of yours by the name of Lex Luthor Corporation has decided they love Joy. They love Joy so much that not only are they going to make her an employee, but they also want to make her part of the business and be a business partner, of course. So over the course of several months, Joy decides that she wants to have a competitive advantage over in the marketplace. And she says, I'm going to take a bunch of information. So she takes with her and copies your confidential client lists. She takes with her your computer program that you developed in-house with the source coding. And she also takes with her the technical drawings of your products. So after a regular IT audit, which is something that we hope that you all do, it's discovered and your IT manager comes up to you and says that massive amounts of data have been downloaded from the server onto Joy's computer and then to an external hard drive. So what we want to tell you is how to avoid a title such as this. Family business downsizes due to Lex Luthor Corp growth. And here's an example of a big fish and the little fish. And if it wasn't for Joy, you would be the big fish and she would be the little fish. So I don't want to focus my part of the presentation on like proper employment contracts and non-competes and NDAs. I want to talk to you about what do you do when actually this all occurs, when you find out that Joy has engaged in this activity. And so one of the best tools, and for the non-lawyers in the audience, one of the best tools in a lawyer's toolbox is something that we call injunctions. And an injunction effectively restrains a party, in this case Joy. It would be able to restrain her from doing something, in this case taking information or using the information, and it would protect the information, or it could actually have the effect of compelling her to do something. And for Joy, it can compel her, for example, to destroy the information that she took, because she wasn't supposed to have it in the first place. Under the umbrella of injunctions, my part of the talk is going to be focused on Anton pillar orders. So an Anton pillar order is essentially an order from the court that, for lack of a better term, it resembles a civil search warrant. So it allows a person, or the complainant, in this case it would be your company, to go into and secure the evidence, secure the external hard drive that she took, or that she copied the information on. It would allow you to seize, for example, the blueprints that she took of your products. It would allow you to take back the customer list and seize that information. It also authorizes you entry into the place of business. So if, for Joy, going to Lex Luthor Corporation, for example, and entering that place of business, or actually going to Joy's home as well. So, as I said, in Joy's case, you go to her house, and you could go to Lex Luthor Corporation's business. So, with respect to Anton pillar orders, one of the main things about an Anton pillar order is that it is an extraordinary remedy. The court looks at it and says, we're not going to give this out lightly. And one of the main characteristics of it that you should know is that it actually is obtained without notice to the other side. So, you know when you see in the movies that people, when the police are at the door and people are flushing things down the toilet and people are burning the evidence, this is supposed to alleviate that from happening because you're not supposed to be providing notice to the other side. But that also means that it's hard to get sometimes, right? Or most times, all times. And so I'm going to talk to you not about all these points, but just 2 points about what you need to show. And the first thing that you need to show is that you have to demonstrate to the court an extremely strong case. So in the case of Joy, you have to demonstrate, or you have to get your IT person to say, no, this is what Joy has been up to, this is how I know this, and I think that she's downloaded everything to external hard drive. There's also another case in which an employee was faxing information, confidential information, from his current employer to a competitor, and then as lots of brilliant robbers do, he walked away from the fax machine, and the fax didn't go through. So the admin assistant came over, saw this fax, said, I should report this to the CEO, and then reported to the CEO, and then there's cases. The case is history because obviously there was trouble for him. So that is one example of how to show the court an extremely strong case. Another thing that you have to show is you have to show damages of the defendant's conduct are serious. It can't just be that this contact list that was taken is something that you can find on a trade association list. You know, it can't be that the computer program that was taken is only worth a couple $1,000s and it really doesn't mean anything to the business. It has to be something serious. So I'm not going to talk about the other points, but needless to say, one of the things you have to tell the court and what you have to show to the court is you have to put your money where your mouth is. The court wants to know that if anything goes wrong, or that if the Anton pillar was given and it should not have been granted, that there is damages that can be paid. So I put this picture up just for sheer humor, because this is not a light subject. I don't know if anybody in the audience watches Suits, the show Suits. Nobody? Yes. So this is Harvey Specter pre his suit days. And this is just to show you that the Anton pillar order, it's serious and it's very coordinated. So you have to make sure the court has to appoint, for example, an independent supervising lawyer who supervises the execution of the Anton pillar. There are police that might have to be on call, locksmiths who might have to be on call, etc. So I'm going to tell you how does this play out practically. I'm going to give you two examples of cases. The first one is when we were acting as the independent supervising lawyer. So we were supervising the execution, the proper execution of the Anton pillar. And this is a case of a plaintiff engineering firm, and with engineering firms, they had quite a few technical drawings and confidential drafting. And of course, as in these situations, there was a disgruntled employee. And he was so disgruntled because he was overworked and underpaid that he decided that he would go work at a competitor's but not tell his current employer at the time. And he was so upset that he talked to a loyal employee and said, I was told by my soon-to-be employer to go after, quote-unquote, the plaintiff's business. And because he wanted to exact revenge on the plaintiff for not paying him apparently sufficiently, that is exactly what he did. And so he took the technical drawings, he took the customer lists and the contact information. And we were supervising the plaintiff who executed the Anton pillar, and we entered into a number of places, 4 factories, the employee's home, and seized a number of things, including USB keys, all kinds of electronic devices, hard copy technical drawings. One thing that you should know about the recovery of information is that you can also extract deleted data. So if you think that, they wiped the laptop, it might not be so. It might be that we can get the right forensic people involved and they can extract that information. And as well, metadata, which is essentially tells you when the information was copied, if it was sent out to anybody, when it was used, can also be extracted. And in the end of this, the plaintiff was successful. So the plaintiff got an Anton pillar, everything went to trial, but the fact that the Anton pillar was obtained meant that the dissemination of the information stopped. So another case example is when we were acting for the Defendants Council. So apparently we were acting for the people who allegedly stole the information. And I say allegedly because we were acting for him, obviously, but he was a former 1/3 shareholder, director, officer, and employee of a custom countertop business. So they manufactured countertops. And he was accused of stealing a customer list with the contact information, as well as a computer program that was specifically designed for the business of the plaintiff. And this computer program, I guess you could say, created labels for these countertops. And when we came in, the Anton pillar was already executed, and we stepped in and moved to set aside that Anton pillar and all the evidence obtained under that Anton pillar. And the reason for that was because there was a complete, in our view, a complete lack of disclosure to the court, because remember, you're obtaining it without notice to the other side. So they don't have a chance to speak for themselves. You have to be 100% truthful with the court and give them all the facts, and then let them decide whether it should be granted. And so in that case, it turned out that the employee/officer was actually forced out of the business, which was not disclosed to the court, that the computer program wasn't really worth anything, that you could create it in a week, and it was nothing through an Excel or a Microsoft program. And so the court did not look very favorably on the plaintiffs as a result of that. And the plaintiffs ended up paying our client costs as well. So this is an example of a successful Anton pillar and a failed Anton pillar. One thing and one saying that has come out of this is, and especially the Anton pillar is very fitting, and we tell all our clients, is if you tell the truth, you don't have to remember anything. So I'm going to hand it to Marie-Andree, who's going to talk to you about other injunctive relief.
This is another headline that you don't want to see in the newspapers. Employee fraud is a very serious problem. Most companies will be victims of employee fraud at one point or another. And the Certified General Accountants Association of Canada estimates that $3.2 billion is lost to Canadian businesses every year because of employee fraud alone. So let's go back to the case of your former employee, Joy. After her departure, you start going through her files and her emails, and you find documents and communications that suggest that a fraud may have been committed. It could be the overpayment of expenses. It could be the receipt of bribes or other advantages from companies you're doing business with. Or it could be illegitimate payments to external contractors, such as ghost vendors or associated vendors. And we've been involved in a file where an employee had set up a number of corporations, and these corporations were purported to do work for the employer, and they invoiced the employer for that work. However, the employee did not disclose to his employer that he had an interest in all these corporations. So after receiving an anonymous tip, we think from the ex-wife of the employee, the employer did an investigation and found out that the employee or members of his family were behind all these corporations. The employer also concluded from the investigation that a lot of the work that it had been invoiced for by these corporations had not in fact been done. And the investigation also revealed that the employee had been approving all the invoices in the computer system using the passcode of another employee. So coming back to your case, what you found in Joy's documents suggests that something is not quite right, but you haven't found what we call the smoking gun or something solid to validate your suspicion. So what can you do in those circumstances? You can seek a Norwich Order. A Norwich Order is an order that you can obtain before a lawsuit is commenced, and it allows you to get information from a third party, so not from the wrongdoer himself or herself. And courts have granted Norwich Orders against all sorts of third parties, but some of the most common are banks. So a Norwich Order can help you to identify wrongdoers, find and preserve evidence to support a court case, and trace and preserve assets. And in order to obtain a Norwich Order, you need to show that you have a valid or reasonable claim, that the third party is somehow involved in the acts complained of. So in the case of a bank, that means that the bank is involved if the misappropriated funds went through the bank. So that's not too complicated to prove. You have to show that the third party is the only practicable source of the information available, so you can't get the information somewhere else. The third party can be indemnified for its costs, and the interests of justice favor the obtaining of disclosure. Norwich Orders have been granted in many cases, including the one I mentioned earlier, where banks were ordered to provide access to relevant bank records. And the review of bank records can allow you to determine whether, in fact, a fraud was committed, who was involved in it, who benefited from it, and where the money went. It can also allow you to potentially take steps to preserve the funds and prevent them from being dissipated. So in the case of Joy, you could seek access to her bank records. You could also seek access to the bank records of the vendors that you suspect to be illegitimate or associated with Joy, so that you can find out who is behind the bank account and follow the money. For instance, after your company paid the vendor, was the money then paid to Joy or a member of her family? So these are things you can find out. Another type of order that you can consider seeking is a Maryville Injunction. Maryville Injunction is an order freezing assets and prohibiting a person from dealing with some or all of that person's assets pending the determination of a court case. So in the case of Joy, you could seek an order freezing her bank account if you can show that her account contains misappropriated funds. However, you need to know that the test to obtain a Maryville Injunction is much more demanding than to obtain a Norwich Order. So you need to show that you have a strong case against the wrongdoer. There's good reason to believe that the wrongdoer will dissipate its assets pending the trial, and the balance of convenience favors granting the order. So Maryville Injunctions and Norwich Orders are legal tools that you can use in a case of employee fraud. However, as you know, there are other ways in which disgruntled employees can harm your company, and another one of them is internet defamation. Defamation involves the publication of a statement that tends to injure the reputation of a person. And a lot of defamation nowadays takes place on the internet. The internet is a fantastic tool that allows you to communicate with a vast and global audience very quickly and very cheaply. However, because of these very qualities, the internet has also the potential to be a medium of virtually limitless international defamation. Going back to Joy's case, after her departure, you become aware of anonymous postings on the internet and also postings by a user called badfamily416. And these postings allege that your company is defrauding its customers by overcharging them for certain services. And you can find those messages on online discussion groups, other websites, public Facebook groups, Twitter, and so on. You also find out that emails containing the same allegations have been sent to your customers from a Gmail account, badfamily416@gmail.com. So your customers are starting to call you, they're angry, and they want an explanation. You suspect that Joy is the person behind all of these messages, but you can't prove it. So what can you do? Well, a Norwich Order can also help you in this type of situation. And let me give you an example. In one case, York University sought a Norwich Order against Bell and Rogers as internet service providers to obtain from them the identity of the anonymous authors of some defamatory emails and website postings. And before seeking that Norwich Order against Bell and Rogers, York University had obtained another Norwich Order against Google to disclose the internet protocol addresses associated with the Gmail account from which the defamatory emails had been sent. As you probably know, each computer connected to the internet has a unique numeric address that attaches itself to every message that are sent from that computer. So an internet service provider has the ability to trace a communication back to its originating computer. So in the York University case, the information obtained from Google disclosed that the anonymous authors of the emails were customers of Bell and Rogers. And so Bell and Rogers were then subsequently ordered to provide the contact information of the customers associated with the IP addresses disclosed by Google. So Norwich orders have been granted in many cases with similar circumstances, and typically respondents like Bell, Rogers, Google, Facebook do not oppose these type of orders. However, they obviously won't disclose customer information unless a court order is first obtained. So in the case of Joy, if you obtain information that links her to the defamatory emails and website postings, you can then sue her for defamation and seek an order prohibiting her from sending more emails and making more postings containing the allegations. In conclusion, so we talked to you today, we talked to you today about some legal tools that can help you deal with harmful actions on the part of disgruntled or dismissed employees. But of course, it's always better to try to prevent this type of conduct from happening in the first place. So it's important to implement control and security measures to try to detect and prevent fraud, and also try to instill a sense of integrity and loyalty in your employees. Thank you very much.